Thank you. I left my cape at home for being a super lawyer. And I know we're running very late on time, and I know I stand between you and food, so I will try to make this as quick as possible. But there are lots of issues to present, knowing the risks of U.S. litigation. So first, just a quick review of the firm. We've been around since 1935, for those of you who don't know. We have approximately 50 attorneys throughout the United States dedicated to defending airlines, manufacturers, insurers, reinsurers, all in aviation. This is what our firm specializes in. Partners and associates combined have over 400 years of experience defending all kinds of airline-related claims, regulatory issues, DOT investigations, everything that you can imagine, and of course, the major losses. Our firm is recognized as handling most major losses, not just in the United States, but really throughout the world, because we'll see about U.S. exposure and how U.S. courts take on these cases, even though they seem entirely foreign to the United States. So the first concepts you need to understand is how that happens. And a court in the United States needs to have both subject matter jurisdiction and personal jurisdiction. So what we look to first is the subject matter jurisdiction, how a court will hear the subject at issue, and personal jurisdiction over the parties. Starting with personal jurisdiction. Personal jurisdiction is present when the court has the authority to make a binding decision over all the parties involved. Now, when a plaintiff brings the case, the court presumes the plaintiff is subjecting itself to the jurisdiction of the court, but then about the defendants is how we get those defendants, foreign parties, for example, into the United States. Most states have long-arm jurisdiction statutes, which explain how that will occur, and the Supreme Court has traditionally upheld what's known as the minimum contact approach. We have another slide that'll detail a little bit of the background as how the U.S. Supreme Court developed these concepts. Non-residents will have maybe minimum contacts with states if they own property in that state or if they somehow do business in the state. And we'll see how the reach of the long-arm statute reaches those foreign entities to come into the U.S. So the federal court will apply a long-arm statute of the state in which the case is brought. Understand, the United States is comprised of 50 individual states. Each state has its own long-arm statute, and when we sit in a court, we have to look at what that state law is. Any party can voluntarily consent to the jurisdiction of the court, but again, without personal jurisdiction, the court can't hear the case over the defendant. If a non-resident party wants to challenge personal jurisdiction, it must do so immediately. If it appears in the court, it will be considered to waive that argument of defense in the first instance. So we're very cautious about how that appearance can be made. It could be as simply as appearing in court. So you must raise the defense immediately. Subject matter jurisdiction. So while we have personal jurisdiction over the defendant and the plaintiff, we also need subject matter jurisdiction. Understand the court system of the United States, while you're all familiar with the U.S. Supreme Court, at the very top of all the courts, we then have a federal court system, and we also have a state court system. We naturally prefer to be in the federal court system where the judges are appointed by the President of the United States, confirmed by the U.S. Senate, as opposed to the state court system, which is generally elected officials. Usually, plaintiffs' attorneys contribute to those campaigns, and they tend to favor then plaintiffs in those cases. So, federal court jurisdiction, though, is very limited. You can get in on federal question jurisdiction, which we can think of Montreal Convention as a treaty, that's federal jurisdiction, or diversity, which would require diverse parties on either side and a monetary amount of $75,000 or more. You can also think of if Air India, for example, was once owned by the government, that would be a foreign state. A federal court automatically has jurisdiction over a foreign state. Why is jurisdiction important? Well, it must be fulfilled to have a successful lawsuit. You have to have subject matter jurisdiction and the personal jurisdiction. If the court does not have jurisdiction over the parties, the lawsuit will be dismissed. If a lawsuit is dismissed, the plaintiff is then responsible for filing it in the proper jurisdiction. So let's talk a little bit. We have more slides on the Montreal Convention, but we have some case analysis as how we treat a case that falls under the Montreal Convention, a treaty that is applicable to the United States and many other states, and how we attach jurisdiction under the Montreal Convention. This case just from 2020 explained in Davidoff versus Scandinavian Airlines is that when you have a personal injury claim or any claim really under the convention, this just happened to be a personal injury claim, where the defendant is a non-US airline, the injury occurred in a foreign route between Sweden and Estonia with no stops to the US. Courts held that the Montreal Convention does not determine the existence of personal jurisdiction. So you'll get into court on subject matter jurisdiction. It's a federal question. It's a treaty involved, the Montreal Convention. But to stay in that court, you need personal jurisdiction. In this case, the court found that it did not have personal jurisdiction over the airline in question. And the decision aligns with the majority of relevant cases that simply explained the Montreal Convention grants subject matter jurisdiction over the case, but not personal jurisdiction over the defendant. And that case was then dismissed. So I mentioned long-arm jurisdiction, or this is how the title of the presentation is long-arm, and see how far the long-arm statute can reach out and grab a foreign defendant and pull it within the court for jurisdictional purposes. It refers to now specific jurisdiction over the party. And there's also general jurisdiction about just doing business in the state. So all states, as I mentioned, have this long-arm jurisdiction statute. Each one is slightly different, but they generally have the same concept. How they will reach out and grab a foreign defendant and pull it into the court for personal jurisdiction purposes. It can be applied in all litigations as long as it conforms with the U.S. Constitution, the state constitution, and personal jurisdiction in the federal courts. Usually defer to the long-arm statute in the state that it sits in. Understand federal courts are spread out throughout the United States as well, so they look to the state in which the case is now based. So this is just a little background about how jurisdiction developed in the United States. It used to simply be territorial. If the accident occurred in the state, the defendant's in the state, jurisdiction exists in the state. And what we saw in 1945 with the International Shoe case is the Supreme Court said, well, we're going to expand jurisdiction as things develop, and if you have minimum contacts in the state, you can then be sued there. You will be considered to have jurisdiction over you in that state because of your contacts with the individual state. And then we've seen other cases develop more recently as to what this means. For example, in the Goodyear case in 2011, the court said, well, you can be essentially home at the state. If you're a corporation, if you're essentially a home in the state doing business, personal jurisdiction will attach to you there. What does that mean? Are you incorporated in the state, or is that your principal place of business? Daimler, in 2014, expanded upon this, holding at what are the places where a company is at home. We looked at the place of incorporation and the principal place of business, where the headquarters is. And then finally, or more recently, was the Ford Motor Company case, which I'll talk to in another couple of slides, is how we look to those business contacts. We look at the Ford case. Everybody knows Ford Motor Company. This was a case in which there were two accidents, and the case was combined from those two separate cases. One accident was in Montana, one accident was in Minnesota, personal injury accidents, car accidents. And they sued Ford Motor Company under a product liability claim. Ford Motor Company moved to dismiss the case, arguing that the claims arise on vehicles not sold in those individual states. They were secondhand vehicles. And they're saying, you can't have jurisdiction over us. Your claims arise out of accidents here, but these cars were sold elsewhere, and that's what your claim is connected to. Well, the Supreme Court did not like that argument from Ford Motor Company. And the Supreme Court said, well, Ford does continuous sales and marketing in these states, as you can imagine throughout the United States they do. And therefore, it was engaged in substantial business in those states, making money selling cars. So it didn't really matter that the cars themselves in those particular accidents were manufactured outside the state. The court found that that was enough of substantial business to hold Ford liable for personal jurisdiction purposes in those states. We can see how this concept now turns to aviation. For example, in Irwin Simpson versus AirAsia case. This was one of the typical, what we see, the hot water spills or hot coffee spills that take place on board an aircraft. And the question is whether, in this particular case, where you have a flight from Malaysia to Cambodia, will a court in the United States exert jurisdiction, personal jurisdiction over the airline? Plaintiff argued that personal jurisdiction existed because the airline maintains a website that is accessible in the United States. But the district court and the appellate court found that the website on its own is insufficient to render airline jurisdiction because there are no flights to the forum, there's no physical presence in the forum other than the website, so therefore they found that personal jurisdiction was not proper and there was a dismissal. However, when we look to another case, in this Wang versus Korean Air case in 2021, similarly, a passenger sued for personal injury damages as a result of a hot water spill on the lap. The court here denied the airline's motion. This was slightly different. You can see the flight was from the United States to South Korea, so there was an initial U.S. connection. Court also found that the airline purposely availed itself of the benefits of conducting business in the state from those contacts. The court noted about the number of flights that it had to the state, that it was registered to do business in the state. And the court then talked about a but-for test, that where the passenger would not have been injured but for the defendant's business contacts with the state. The court determined that the plaintiff's claim arose from those contacts in the forum, and as such, the court in this case found personal jurisdiction over the airline. In additional personal jurisdiction and subject matter jurisdiction, another concept we deal with frequently when cases are brought is forum nonconvenience. This is slightly different because in this case, this is where we're seeking to have a court decline or exercise jurisdiction over a case and dismiss it on the basis that there is another jurisdiction that's better in the world. It could be anywhere in the world, but the court is going to look and see, is there another jurisdiction that's better than the United States to hear this particular case, whether it's appropriate for that. What principles does the court consider? Well, first we look to the plaintiff's choice of the forum, and as you will know, many people like choosing lawsuits in the United States where damages are higher. But then the court will look to whether there is an adequate and available alternative forum somewhere else in the world. And in doing so, the court then will turn to public and private factors, a balancing test, so to speak. So when the courts look to what private interest factors are to be considered, they will look to where the evidence is located, where the witnesses are located, who investigated the accident, and where is the wreckage being stored. Those are the private interest factors. Courts will also look to public interest factors. This is facts that the court considers to best serve the interests of justice. So we can look to whether the case is of sufficient U.S. interest to expend the court's time and resources. Are there competing U.S. interests versus a foreign interest? If you can imagine a crash or a loss totally overseas, why is a U.S. court so interested in hearing such a case? And will the court be required to apply a foreign law? In other words, is there another court that is better suited to apply foreign law? So general jurisdiction, we've seen, I mentioned in the slide before under Daimler, it's slightly different than what we see under forum nonconvenience. Okay? Daimler and those cases that we saw where a court will exercise personal jurisdiction over defendant, looking at the place of incorporation, the place of the business, due process considerations, versus forum nonconveniens, where a court has jurisdiction, but now will dismiss it because there's a better place for the case to be heard. Here's a few cases now addressing these issues. So we can see Abood versus Boeing in 2018. This is a crash in Dubai International Airport, where the crew overshot the runway on approach. The aircraft was designed not to lift after the wheels touched the ground, and of course we have a lawsuit in Cook County, which is based in Illinois. It is one of those described as a judicial hellhole in the United States, where the plaintiffs are given very favored treatment. So one place we do not like to be is Cook County, Illinois. Unfortunately, Boeing is based in Cook County, Illinois. So if you're involved in a crash or a loss involving a Boeing aircraft, there's going to be jurisdiction over Boeing in those courts, in state court. So 14 passengers here sue in Boeing in Cook County, and Boeing moves to dismiss on forum nonconvenience grounds. Boeing's motion was denied. Boeing is headquartered in Cook County. Citizens in all jurisdictions have an interest in having a product liability case concerning the aircraft, the Boeing aircraft, to be heard in Cook County. Evidence and witnesses to the crash while they're located in the UAE, but the court considered not just those factual connections. The court believed that Boeing's concern that those witnesses would refuse to testify was merely speculative. The court kept that case. Again, a wholly foreign accident, but because the aircraft itself was manufactured by Boeing, the court in Cook County keeps the case. In air crash over the southern Indian Ocean. This is the disappearance of the Malaysian aircraft back in 2014. Lawsuits were filed in Washington on behalf of passengers, two places, Washington, D.C. and Kuala Lumpur, Malaysia. The defendants were Boeing again, Malaysian Airlines, and the insurer. And they all moved to dismiss those cases. The defendants argued that the lawsuit should be brought in Malaysia. Now here, it was explained to the court the flight was operated by a Malaysian airline. Its last contact was with the Malaysian traffic control, and claims turned on the validity of Malaysian statute. But several passengers were U.S. citizens. Boeing was an American company, and the location of evidence was really a neutral factor as several nations were involved. So you can see the balancing test that's going on. But in this case, the court found that the Malaysia's interests outweighed those of the U.S. interests, and on forum nonconvenience grounds dismissed the case. Another case, Siswanto versus Airbus. This was the crash from Subrahaya in the Java Sea. And jurisdiction was based on a multi-party, multi-forum Trial Jurisdiction Act. Gets a little complicated, but this is another grounds for subject matter jurisdiction when you have an accident that involves more than 50 persons in one dedicated incident. You can have federal jurisdiction, subject matter jurisdiction, based on that ground. So here, motions were filed by Airbus due to lack of personal jurisdiction over the aircraft manufacturer. Airbus's contacts with the U.S. were insufficient, although they did have 6% of sales, which was in the millions of dollars, multiple millions of dollars, and subsidiaries did exist in the U.S. I believe it was Alabama, and of course Airbus markets its aircraft in the United States. The court found that this was not sufficient, and forum's nonconvenience motion was granted. Arising from the same loss was another case now filed on the West Coast in the state of Washington, SIA versus AirAsia. It was the same facts, it was the same crash. Now the defendants were different defendants. They went after AirAsia and Artis. They were related on a Daimler dismissal. So plaintiffs argued that contacts over those defendants existed sufficiently to create personal jurisdiction. Again, we saw the website arguments. We saw servers. They were arguing that the website servers were actually based in Seattle, that rendered the defendants at home simply because they were operating the website worldwide and using servers in the United States. But fortunately, the court dismissed the case on these grounds, finding that affidavits which we provided, that we were not incorporated in the state of Washington, principal place of business was not the state of Washington, and simply hosting websites with minimal contacts. It didn't render those defendants at home in that jurisdiction, and the court dismissed the case. We'll talk a little bit now about jurisdiction under the Montreal Convention, which was touched upon when it was introduced by Chris, Montreal Convention on Accident Liability. As you know, the Montreal Convention replaced the Warsaw Convention. Essentially, the case law adopted previously is still being used today, but we are seeing tweaks, as Chris mentioned, in the accident side of things. But we also have some additional changes in the terms of the Montreal Convention, specifically as to jurisdiction. The Montreal Convention applies to all international carriage. We see it especially when you have U.S. transportation, round-trip U.S. transportation, even to a state that is not a party to the convention. So under the convention, we look to where there could be jurisdiction, the jurisdiction of Article 33. So you have the domicile of the carrier, its principal place of business, the place where the ticket was purchased, and the place of destination. Montreal Convention added what is known as the fifth jurisdiction, which is, in the case of personal injury, the principal and permanent place of residence of the individual plaintiff. So this was an expansion from the previous Warsaw Convention, and the Warsaw Convention, where some citizens who purchased tickets abroad for flights but did not depart from or have an airline in the U.S., they were prohibited from suing in U.S. courts. Well, Article 33 was intended to resolve that problem, to allow someone who is a permanent resident of the United States to maintain an action under certain circumstances, which we'll talk about now. This is Article 33, the fifth jurisdiction, Article 33.2 to be specific. Just lays out what it says. I have another chart that might be easier. And again, it was intended to cover situations where an airline operates its services to or from the passenger's domicile, either by way of its own aircraft or by a code-sharing agreement. And we'll talk about this in a second with some other slides, because with the adoption of code-share agreements, which really didn't exist when the Warsaw Convention was created, is the drafters of the Montreal Convention decided to rectify that problem by enacting Article 33.2 and expanding that possibility even with Articles 39 and 40 of the Convention. I have those slides as well, to get jurisdiction over those carriers. So here, under the Warsaw Convention, and some countries still apply the Warsaw Convention, courts held that a passenger may seek recovery only against the actual carrier and not the contracting carrier, not the carrier that sold the ticket. If we can think back to the disaster involving Swissair 111, many of those passengers bought Delta airline tickets, and then they showed up to fly that route from JFK, and they got on a Swissair flight. And when Swissair 111 crashed, those passengers had a little bit of a problem, because under the Warsaw Convention, you could only sue the actual carrier, but yet they didn't have a ticket with Swissair. So to rectify that problem, as I say, the Montreal Convention addressed this code-sharing issue where passenger purchased a ticket from one carrier, the contracting carrier, but all or part of the carriage is performed by a different carrier. So for the fifth jurisdiction purposes, this is more of a visual slide. It shows you what needs to be satisfied to get jurisdiction over the foreign carrier into the United States, where it won't apply if there's no death or injury to passenger. That's required for fifth jurisdiction. The passenger must have principal and permanent residence in the jurisdiction at the time of the accident, and the court will look to the rationality of the passenger, what they believed their residence was at the time of the accident. There must be a suitable presence in the country, and the air carrier must operate services for carriage of passengers to or from that state, either by its own aircraft or by another carrier's aircraft pursuant to a commercial agreement. So what determines principal and permanent residence? In the Hornsby case, which is one of the first cases that dove into the fifth jurisdiction, we had a plaintiff who was a U.S. citizen living and working in Germany. And they sued Lufthansa for an injury they sustained on a flight from Frankfurt to Los Angeles. That the plaintiff's intent to return to the U.S. though not her nationality. That was the principal place of residence, and the dismissal was denied on that ground. Let's talk a little bit about Article 39. This is where the passenger has the option of seeking damages either from the contracting carrier, meaning the carrier who just sold the ticket, versus the actual carrier, the carrier on which the event occurs. So the hot coffee spill occurs on that particular flight. There is a distinction in the article as to what is successive carriage. So successive carriage would be where a carrier sells the ticket and transport the passenger part of the journey, but then the incident may occur on the other half of the journey on a totally different carrier. This case was the first case that addressed this issue and explained it well. Best versus BWIA in New York. So what happens in this case is it was a woman who boards a flight, purchases her ticket to fly from New York to Grenada via Port of Spain, Trinidad. So the first leg of the flight would be on BWIA. The second leg of the flight will be on Liat Airlines. As she boarded the Liat Airlines flight, she is mistaken to be someone else and is ungraciously thrown from the aircraft down the air stair and sustains personal injuries by some security officials. She then is apologized to, and she comes back on the plane and takes the flight to Grenada. But when she returns to New York, she finds a good lawyer who decides to file a lawsuit, but only against BWIA. Now, BWIA sold the ticket, so you would think it would be a contracting carrier, but it's not, because it provided the first leg of the transportation from New York to Port of Spain. And because BWIA performed some of the transportation, it was deemed to be a successive carrier, which is what we argued in the case, and the court agreed. The court agreed that when you're a successive carrier, the only party that can be sued is the party who performed the actual carriage when the injury occurred. Here, because the person had boarded a Liat flight in Trinidad, and that was the flight she was ungraciously thrown off of and injured from, that's the carrier who deserved to be facing liability in the U.S., and the case was dismissed. The court also pointed out that there's no evidence of a connection, like a code-share arrangement or anything like that between the two carriers, and none did exist. So this is Article 40, which talks about the same concepts that we just mentioned as to how you get liability over the contracting carrier, in addition to the successive carrier. There can certainly be a situation in which both two carriers would face liability. If, for example, BWIA only sold that ticket as a contracting carrier, did not perform any transportation, just going back to the idea of the Swissair 111 loss, Delta Airlines sold that ticket to those passengers, but the transportation was wholly provided by a different carrier, the actual carrier. Liability will be addressed to both carriers in the situation, contracting carrier and the actual carrier. But when you are a successive carrier, meaning performing part of the transportation, only the actual carrier will face liability in the United States under the Montreal Convention. So I went fast. This, I believe, is my last slide. So it gives you an idea as to how you can get dragged into the U.S. under long-arm jurisdiction. Court must have personal jurisdiction over the defendant as well as subject matter jurisdiction. And we saw the fifth jurisdiction of the Montreal Convention and how a plaintiff, because of their permanent and principal residence, can claim jurisdiction under the Montreal Convention under Article 33.2. If you have any questions, I'll be here for the rest of the day, and I'm more than happy to assist. Thank you.